Hello everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. In this video, we're going to talk about U.S. halts all asylum decisions after National Guard shooting. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. The Trump administration has announced it is halting all asylum decisions in the wake of the National Guard shooting in Washington, D.C., according to a senior immigration official, Joseph Edlow. The director of U.S. Citizenship and Immigration Services said in a post on X on Friday that asylum decisions will be paused until we can ensure that every alien is vetted and screened to the maximum degree possible. The video came as charges against a man accused of shooting two National Guard members have been upgraded to first-degree murder after one of the soldiers died, the U.S. Attorney for the District of Columbia announced on Friday, while investigators continue to seek a motive. Specialist Sarah Beckstrom, 20, and Staff SGD Andrew Wolf, 24, were hospitalized in critical condition after the Wednesday afternoon shooting near the White House. Donald Trump said on Thursday evening that Beckstrom had died. U.S. Attorney Jeanine Pirro's office said the charges against Romano Lacanwil, a 29-year-old Afghan national who worked with the CIA during the Afghanistan War, now included one count of first-degree murder and 2 counts of assault with intent to kill while armed. Beckstrom and Wolf were deployed with the West Virginia National Guard as part of Trump's crime-fighting mission that federalized the D.C. police force. The president also has deployed or tried to deploy National Guard members to other cities to assist with his mass deportation efforts, but has faced court challenges. Trump called the shooting a terrorist attack and criticized the Biden administration for enabling Afghans who worked with U.S. forces during the Afghanistan war to enter the U.S. Trump has said he wants to permanently pause migration from poorer nations and expel millions of immigrants from the country. In an interview on Fox News, Pirro said there were many charges to come beyond the upgraded murder charge. She said her heart went out to the family of Beckstrom, who volunteered to serve and ended up being shot ambush style on the cold streets of Washington, D.C. Pirro said officials have been working around the clock to determine the suspect's motive. Investigators were executing warrants in the state of Washington, where Lacanwil lived, and other parts of the country. Wolf remained in very critical condition, West Virginia's governor, Patrick Morrisey, said on Friday. He ordered state flags to be flown at half-staff in recognition of Beckstrom's death. Lacanwil has been living in Bellingham, Washington, about 80 miles, 130 kilometers, north of Seattle, with his wife and 5 children, said his former landlord, Christina Widman. Lacanwil entered the U.S. in 2021 through Operation Allies Welcome, a Biden administration program that resettled Afghans after the U.S. withdrawal from the country. Officials said Lacanwil applied for asylum during the Biden administration, but his asylum was approved under the Trump administration. Afghan EVAC said in a statement. In a Thanksgiving address to troops Thursday, Trump said Lacanwil went cuckoo. He went nuts. On Wednesday night, the president called for the reinvestigation of all Afghan refugees who had entered under the Biden administration initiative that brought roughly 76,000 people to the country, many of whom had worked as interpreters and translators. The program has faced intense scrutiny from Trump and others over allegations of gaps in the vetting process, even as advocates say there was extensive vetting, and the program offered a lifeline to people at risk of Taliban reprisals. Trump admin moves to resume sharing Medicaid data with ICE. The Trump administration on Friday informed a federal judge it intends to resume giving immigration officials access to personal information about Medicaid recipients from 22 states, over objections from Democratic state attorneys general. The notice from the Centers for Medicare and Medicaid Services opens a door for the administration to potentially resume transferring tranches of confidential Medicaid data, including phone numbers, addresses, and immigration statuses, to Immigrations and Customs Enforcement as soon as next month. It comes despite California and 21 other states suing in July to prevent the transfers and initially winning a temporary freeze. Those states will have another opportunity to challenge the move at a court hearing scheduled for December 9th. Justice Department Attorney Michael Girardi said during a court hearing Friday that the CMS notice, as well as a related November 17th IC memo, met court-imposed requirements to resume sharing Medicaid info with immigration officials. His arguments came in response to a preliminary injunction handed down in August from San Francisco-based U.S. District Judge Vince Chabria. Chabria's order temporarily blocked Medicaid data from being shared for immigration enforcement, but said the injunction would be lifted 14 days after the agencies completed a reasoned decision-making process. California's legal team, however, countered that the agency's notices appeared inadequate. My initial impression is they aren't what the court ordered in terms of a reasoned decision-making practice, California Deputy Attorney General Anna Rich said during the hearing held by video conference. Chabria encouraged the federal government to delay resuming data sharing until after the holidays, just to make everyone's life easier. Girardi said he'd take the suggestion back to Trump administration officials for consideration. The Trump administration has struggled to defend its seizures of government data to meet the president's goals for mass deportations. A federal judge on Friday in a separate case temporarily barred the Internal Revenue Service from sharing tax information with immigration officials. CMS has already shared Medicaid data from California and a handful of other blue states with ICE. The agencies have been prohibited from using the information for immigration enforcement since Chabria's August ruling. HHS has insisted the transfer is supported by lawful interagency data sharing and is focused on identifying waste, fraud, and systemic abuse of Medicaid benefits. California Attorney General Rob Bonta and other Democratic attorneys general challenging the data transfer argue it's an illegal move designed to foster a culture of fear that discourages undocumented immigrants from accessing health care. The CMS notice is scheduled to be published in the Federal Register on November 25th. The existing preliminary injunction blocking information sharing will remain in place for 14 days after the formal publication. A court hearing to determine whether to extend the court's temporary order freezing Medicaid data sharing is scheduled for December 9th. Legal status of 350,000 Haitian migrants to expire in early February, U.S. officials announce. The Trump administration announced Wednesday a renewed effort to terminate the temporary protected status of more than 350,000 Haitian immigrants, saying they will be eligible for deportation in early February unless they have other legal means to remain in the U.S. Homeland Security Secretary Kristi Noem made the decision after the Trump administration's initial attempts to end the TPS protections of hundreds of thousands of Haitians earlier this year were stalled in federal court. Noem acknowledged the humanitarian and political problems faced by crisis-stricken Haiti, including what she called widespread gang violence, but said extending the TPS policy would be at odds with U.S. interests. Based on the department's review, the secretary has determined that while the current situation in Haiti is concerning, the United States must prioritize its national interests, and permitting Haitian nationals to remain temporarily in the United States is contrary to the U.S. national interest, the official DHS termination notice said. The TPS program for Haiti is now set to expire on February 3rd, and the termination is expected to affect 352,959 beneficiaries, DHS said in its notice. Trump administration officials have urged TPS holders whose status is set to lapse to self-deport or face the prospect of being detained and forcibly removed from the U.S. TPS allows beneficiaries to work and live in the U.S. without fear of deportation for time periods outlined by DHS. The humanitarian program was created by Congress in 1990 to allow administrations to grant a temporary safe haven to foreigners from countries facing an armed conflict, an environmental disaster, or other emergencies. The Biden administration vastly expanded the TPS policy, offering protections to hundreds of thousands of new arrivals from Afghanistan, Haiti, Ukraine, Venezuela, and other countries. Some of those who benefit from TPS entered the U.S. illegally, most commonly along the southern border, while others arrived legally on temporary visas or programs. As part of its government-wide immigration crackdown, the second Trump administration has sought to dismantle most TPS programs, revoking or moving to revoke legal protections for hundreds of thousands of Afghans, Burmese, Cameroonians, Haitians, Hondurans, Nepalese, Nicaraguans, Syrians, Sudanese, and Venezuelans. The Trump administration has argued the TPS policy has been abused by Democratic administrations, exploited by bad actors, and extended for too long, even though it is designed to be temporary in nature. In some cases, it has argued conditions in countries with TPS have improved, and in other cases, it has said that extending the program would not further U.S. interests, even if conditions in the affected nations remain dire. In its notice Wednesday, DHS argued the TPS policy for Haiti was a magnet for illegal immigration, and that continuing the program posed national security and public safety risks. It cited concerns about its ability to properly vet Haitian migrants, and cases of some TPS holders from Haiti being implicated in immigration fraud or national security investigations. Judge Halts IRS sharing of taxpayer info for immigration crackdown. A federal judge on Friday barred the IRS from sharing tax return information that immigration officials aim to use to deport undocumented immigrants, saying the practice violated a taxpayer confidentiality law. U.S. District Judge Colleen Collicatelli, a Washington-based Clinton appointee, ordered the tax agency not to disclose the confidential address information of tens of thousands of undocumented taxpayers to Immigration and Customs Enforcement until the court can review the case further. Collicatelli also blocked Treasury Secretary Scott Bessent, who also serves as the IRS's acting commissioner, from disclosing any taxpayer information to the Department of Homeland Security unless the person receiving it is working on a relevant non-tax criminal investigation. On August 7th, under a controversial agreement between Bessent and Homeland Security Secretary Kristi Noem, the IRS disclosed confidential address information for about 47,000 taxpayers to ICE to aid in the Trump administration's deportation agenda. The Center for Taxpayer Rights, joined by several other groups, has sued to halt the exchange of information, saying it violated a federal law that heavily limits taxpayer data sharing, except when it's necessary for a non-tax federal criminal investigation or proceeding in which a federal agency has obtained approval from a court or agency head. Court filings showed the IRS and ICE worked for months to get around these restrictions, partly by slapping a federal criminal penalty for failure to leave the country on the undocumented immigrants whose information ICE requested. Bessent and Noem signed off on the effort. In her opinion, Collicatelli wrote that the Center for Taxpayer Rights and the other plaintiffs had shown that the IRS's sharing of the addresses with ICE was illegal because it didn't comply with some requirements in the taxpayer confidentiality law. She also said the plaintiffs have plausibly alleged that the agreement violated federal administrative procedure rules. The IRS's unlawful conduct has created a substantial likelihood that plaintiffs and their members will suffer irreparable harm. The Center for Taxpayer Rights is experiencing a significant decline in interest and engagement with its core activities of providing pro bono services to low-income taxpayers, including immigrant taxpayers, potentially jeopardizing its federal funding, wrote Collicatelli. Meanwhile, she added, plaintiffs' members face an imminent risk that the confidential address information they have provided to the IRS will be impermissibly used by ICE for civil immigration enforcement. The order keeps the agencies on a tight leash. Collicatelli required Homeland Security to notify the court and Center for Taxpayer Rights of any further requests from the agency. And if the IRS determines that disclosure to DHS or its subagencies is lawful, she will also require the IRS to give the court at least a 72-hour notice, along with information ensuring the agencies are compliant with the confidentiality law before handing off the data. The order also requires Bessent to notify Noem and IC Director Todd Lyons by Monday that the Immigration Enforcement Agency should limit access to the return data disclosed on August 7th to staffers who are personally and directly engaged in a non-tax investigation. Skye Perryman, who heads Democracy Forward, a group that represents the plaintiffs, said, "The privacy laws enacted in the post-Watergate era exist to prevent abuses of power like this, and yet leaders in the IRS and IC launched this effort. Paying your taxes does not forfeit your right to privacy. TSA to start charging travelers $45 if they don't have a real ID. Here are the details. U.S. air travelers who haven't upgraded to a real ID can still fly without one, but starting February 1st, they'll be charged a $45 fee, the Transportation Security Administration said Monday. Flyers without a real ID, a passport, or another acceptable form of ID will need to have their identities confirmed through a fee-based verification system called TSA Confirm.ID, the agency said. The announcement of a $45 fee for people without real IDs comes after the TSA started requiring the identification or other approved documents in May. The real ID is a federally compliant state driver's license, learner's permit, or non-driver ID card, identified by a black or gold star in the upper right corner. Passengers without real IDs will be referred to the optional TSA confirmed ID process for identity verification upon TSA check-in and prior to entering the security line. The TSA said the process will vary from airport to airport, according to the agency, which said it is working with private vendors to allow consumers to pay for the screening process before they arrive at the airport. The TSA warned that people without real IDs can encounter increased wait times at airports while their identities are verified. The fee verifies passengers for a 10-day period, according to the TSA. The agency is still urging passengers without real IDs to visit their local DMV to update their IDs. The $45 fee is designed to ensure that travelers, not taxpayers, foot the bill for the advanced verification system, said Adam Stahl, a TSA official, in the statement. Some travel experts said the new fee disadvantages lower-income Americans and that the 10-day verification window could cause confusion. The policy creates a bizarre situation where your identity expires like a carton of milk. Travel expert Julian Keel, founder of flight search engine Points Path, told CBS News. After those 10 days pass, you're back to square one, forced to pay another $45, even though nothing about your actual identity has changed. How does Confirm.ID work? Confirm.ID asks passengers without real IDs to answer a series of questions about themselves to verify their identity. Once a passenger's identity is confirmed, they'll receive a receipt to show a screening agent at the TSA checkpoint, along with their form of ID. They will then continue through security, like all other passengers. Passengers who don't have real IDs and opt not to pay the $45 fee may be denied entry at checkpoints. The TSA said Monday during a press call describing the new fee-based program. What's an acceptable form of ID? Travelers with real IDs or other accepted forms of identification don't have to pay the $45 fee to travel. Here are some of the documents the TSA says can substitute for a real ID-compliant driver's license. State-issued enhanced driver's license or enhanced ID, U.S. or foreign government-issued passport, U.S. passport card, DHS Trusted Traveler Cards, Global Entry, Nexus, Sentry, Fast, U.S. Department of Defense ID, Permanent Resident Card, Border Crossing Card. The TSA's website has a complete list of compliant types of IDs. Who has a real ID? The TSA noted that more than 94% of passengers currently use real IDs or other acceptable forms of identification. The TSA had previously proposed a rule that would charge travelers without a real ID an $18 fee at security checkpoints, according to a notice published in the Federal Register earlier this month. The cost of getting a real ID varies by state. New York, for example, has no additional fee for a real ID beyond the regular cost of getting a driver's license or renewing it, but Pennsylvania charges a one-time $30 real ID fee on top of standard renewal fees. That is all for today in this video. See you later in the next video. Till then, take care